Mara.
Oops. Back to Zoom. Now, why can't I? Let's try this again. There it is. Slideshow. There we go. Can we see, everybody see okay?
We sure can. Yep.
Okay. Thanks for being here this morning. A couple things before we start off. As I noted earlier, I am an attorney. I work for Security National Bank. One of the things of working as an attorney for a trust department is we cannot practice law outside of managing the internal things going on here in the bank. But I can't answer people's questions. I encourage you, if you do have questions after we visit, each person should find an attorney that they feel comfortable with, that is familiar with probate. Different attorneys have different specialties that they practice in, but you should always seek good, sound legal advice and follow the advice of the attorney. One of the challenges when I was a partner in a law firm, and one of the biggest challenges that I think most of us in practice run into is that people go out and do things and get themselves into situations and then come along and ask, can you get us out of this problem? And it really works so much better if people come to us at the beginning and say, I'm thinking about doing this. How do we do this and avoid problems? Particularly today, as there are a lot of people that are entering into legal relationships with other people without the benefit of any formal type of agreement. A lot of people that are living together today are doing so and are not married, and so therefore how that relationship as they buy assets and dispose of assets and when they die, how those things play out is very different than a person, let's say, who's married. And so I strongly advise you to get advice in advance. Now, the topic today started off as trust, but really to understand what a trust is, you need to step back a little bit and ask yourself, well, what is it that I'm really trying to accomplish? And a trust is a tool to accomplish a certain thing. And today we're going to be talking about principally how to move your assets from yourself to benefit somebody else, either temporarily or permanently. Now, one of the ways that that happens is at death. When a person has a will, those assets are normally guided by the will. And one of the things that drives
Lost connection.
One of the things that drives many people to consider trusts is because they hear on radio and TV and various magazines that you've got to do everything you can to avoid probate because it's equivalent to a social disease. And so trust is one reason to do that. Admittedly, there are situations out there where when probating a will, it can get very contentious and very difficult, and it can get very expensive. But that's not necessarily because of the process. As it says right there on the screen, probate is the legal process of validating the final will in court, providing for court supervision and collection and distribution of the assets, payment of the final expenses, and filing tax returns. One of the things that we run into most often is with family members, if there is a disagreement about how assets are going to be distributed, the first question comes up is the document that is purporting to be the will truly the intent of the person? And did anybody use undue influence on that person to get them to favor one side or another? Or did they at some time cancel that will? You know, what about if there are terms in there that are conflicting? With a trust, unless you submit the trust to court, which is very similar to probate, you don't really have a neutral party deciding as a matter of law, this is what the provisions are. And so the probate process first looks at a will and says, yes, this was the intent of the person. They were of sound mind at the time they executed the will, and this is what they want to do. In that will, there can be provisions for trusts and other things, but the court makes that determination. And everybody that has an interest is noticed, and they have the opportunity to discuss it and present evidence to the court as to whether or not this is valid. I can tell you in the trust process, because a lot of trusts are not before court, the question that some of the beneficiaries have, if there is a disagreement between the beneficiaries, is the trustee fair and impartial as they are dividing up the assets? Today, where half the marriages in the United States end in divorce statistically, we see a lot more situations where it's a second or third marriage and there are children possibly from the first and second marriage. And as assets are set aside to benefit a surviving spouse, let's say the second or third surviving spouse, some of the children from the first or second marriage feel disadvantaged and actually get angry, and then they begin to argue those questions. And so it's the supervision, the idea that people have a fair and impartial person deciding that this is in fact the will, collecting the assets and distributing the assets. It's not uncommon for people to loan assets out to somebody else with the expectation that they're going to come back, or loan money, and for the executor, they have to sometimes collect that, and the people may not be in a position to give it back or may not be willing to give it back. So there can be disagreements there. Again, the court's in a position to issue an order to make sure that that happens, to make sure that expenses get paid, the appropriate expenses, not just funeral expenses, but particularly the filing of the final tax returns, because you're going to have a state and, a federal, and in Nebraska and Iowa, you're going to have state income tax returns that will need to be filed for the final year when the person was alive, making sure that you get clearance from the government saying, yes, we accept those returns and there's no tax due. And then there may be taxes, either federal estate taxes or inheritance taxes. Both Nebraska and Iowa have inheritance taxes. They don't apply to distributions to all beneficiaries, but if you are in the possession of assets that are owned by a person who dies, and you distribute those assets to someone, and later on you come to find out that there was outstanding taxes that were due, the government can come after you for the taxes, even though all you were doing is just distributing the money. So making sure that all the I's are dotted and the T's are crossed. Probate is a good thing. So wills sometimes are appropriate. Most often, even when a person has a trust that disposes of their assets, we're going to draft what's called, or the practicing attorney is going to draft what's called a pour over will, which will take any assets that are not in the name of the trust and pour them into the trust, so as to clean everything up. But basically at the bottom there, the executor or the personal representative is the person who wraps up your affairs and distributes your property. Now, when we talk to people about estate planning, the big questions are who gets what? Who do you want to benefit? And what assets do you have to leave for them? And how are you going to get them in that position? You may want to benefit somebody just with, for example, the life income use of property and not give them the actual property itself. You might want to let them have the rents off of a farm, for example, but then pass the farm on to grandkids. You may have a person who is a spendthrift, who you're really worried that if you give them the assets, they'll dissipate those immediately and they'll have nothing for the rest of their life. So you have to ask yourself, what is it that I'm trying to accomplish? Who do I want to benefit? And what assets do I have to leave for them? I strongly suggest for everyone that you compile a balance sheet of what assets you have, the things that you own, such as savings accounts, checking accounts, securities, insurance policies, annuities, retirement accounts, physical property, anything of that nature. The next question that creates a lot of anxiety on the part of most people is, how much is the government going to take of those assets? What is it going to cost to move those assets to get that done? Those are the two things we need to address. Now, up until 2026, unless Congress changes it, most people are not going to have to worry about what's called the federal estate tax, because federal estate, the federal estate tax exemption was increased to over $11 million per person. And so a married couple can pass in excess of $22 million without paying any federal estate tax. Inheritance tax generally to spouses or immediate blood relatives is very, very low, if at all. Like Iowa, for example, exempts most immediate relatives from inheritance tax. But federal estate tax is the one that scares most people, because if it kicks in, if you do have to pay federal estate tax, it begins at about 40% of whatever is subject to the tax. So it gets real expensive real fast. The thing about probate, going back to the advantage of probate, is it handles both the transfer of title and the payment of tax, while probate avoidance, the things that we're going to talk about in a few minutes here, will handle the transfer of the assets, but you're still going to have to address the tax issue. Occasionally, we'll run into a situation where somebody had property in joint tenancy with a child in a state that has inheritance tax for children, such as Nebraska. And the person dies, the asset passes to the child, and there is no inheritance tax determination. And when the child goes to sell the property, the title company goes out there and they find, oh, wait a second, there's a lien out there on the property for this undetermined amount of inheritance tax that is due. And that could hold up the sale because most people, or hold up the refinancing, because most lenders are not going to want to loan on property that has a cloud on the title. So transfer tax, getting all of those things cleared up is very important. And particularly if you're the one distributing the assets, as I mentioned, you don't want the government coming back to you later on, even though you didn't get any of the assets. They come back to you and say, oh, by the way, there was an outstanding income tax due for that last year of $4,000, and there's interest on it, and you owe that. So too bad. We'll move now to just the basics here. Legal title. Who gets what depends on how property is owned. There can be a thing called a life estate. And what a life estate is, for example, I can give to a person the use of a house or a farm or whatever for their life. They can't borrow against it. They're not really supposed to make any substantial improvements or changes to it. They can't sell it, but they get to use it. And like in the case of farm ground, you get to collect the rents off of it during your lifetime. This is nice because for that person, they get income during their lifetime, and then at their death, with just the filing of the death certificate, whoever the remainder beneficiaries are, might be children, they become the automatic owners of that property. And so life estate becomes very simple in terms of passing the assets. There are some downsides to the life estate, however, because we have seen situations where a person is either left a life estate or an estate for a period of years, let's say 10 years, and suppose the property that's left to them is a house or a business, and that business falls into disrepair. It needs a new roof. It needs the foundation starts to go, or there are other issues that make the building unusable or unlivable. Well, who makes the payment to improve that? And suppose somebody wants to sell the property. They don't necessarily want to keep the property anymore. Well, if the life tenant abandons the property, then and gives up their use, the remainder beneficiary may be able to sell the property, then clear the title. But you got to go through the proper steps. And so a life estate has some use, but it is it's a little bit more complicated for some people than some of the other options. The most common thing we see in title options is joint tenancy with right of survivorship. You'll see it on various things, JTWROS, or joint tenancy. Sometimes people used to say if you had Bob or Mary in a document, you put the word or, that would create a joint tenancy. Most practicing lawyers are going to spell out joint tenancy with right of survivorship. Where you're going to see this most often is where you've got a husband and wife and they want to leave the assets to their spouse at their death. The thing about joint tenancy with right of survivorship is that at the instant of death, the property becomes owned by the survivor, and all that needs to be done is a death certificate filed. And as far as the title goes, then the title passes to the surviving spouse or whoever the joint tenant is. Where we see it a lot is with houses, cars, checking accounts, things of that nature. What's great is it provides immediate liquidity for the estate. If it's a checking account or savings account, you don't have to close it out or anything. It just becomes automatically owned by the survivor. Now, one thing about that, I would say if you encounter that situation, the checking account or savings account is probably affiliated with a social security number. And if the social security number is that of the deceased person, you're going to need to change the social security number over to the survivor so that the taxes get correctly reported. Otherwise, any interest that gets paid over in the future after the date of death is still going to be attributed back to the decedent, and it confuses things when you're trying to file that final tax return. One of the things about joint tenancy with right of survivorship, though, is that it doesn't really work as well for children or other parties, because when you create a joint tenancy with another person and you file that deed or that document, you actually give them a present interest in your property. And if one of your kids, for example, you put one of your children on there as a joint tenant, and that child goes out and gets into serious automobile accident that is their fault and they get a judgment against them, when that judgment creditor starts to look for assets, they may find this account. And even though that child didn't contribute anything to it, and even though a court ultimately might not award some part of that account to the judgment creditor, you don't want to get messed up in that and mixed up in that. And that's one of the things that can happen. Also on joint tenancy, question comes up, can you sever a joint tenancy? And as people are encountering marital difficulties or divorce, you know, the joint tenancy becomes more problematic because normally either joint tenant can come into a bank and take out all the money in the account, for example. And so if you have a married couple that is experiencing difficulties, one of the spouses, to protect themselves, may go in and strip out all the assets in the account, which they're legally authorized to do. Another thing that comes up with joint tenancy for people that have several children, they may have one child that is living nearby and they want that child to be able to help them pay bills. And so instead of making the child an additional signer on the checking account, what they do is they make them a joint tenant, but don't put the other kids on as joint tenant. And the child who's the joint tenant most often will say, well, if anything happens to you, mom or dad, don't worry, I will just split this up with my siblings. Well, years go by, they are the on-site caregiver. They do a lot more for mom and dad than the two non-proximate siblings. The parent dies, and at that point they go, well, mom intended that I have all of the checking account for all the work that I've done. And as a matter of law, that property becomes theirs. Now, they can argue that there was undue influence or whatever, but again, all that happens then is when you end up in court arguing about something, the only people that make money there are the attorneys. And so trying to avoid those issues, if you do have that situation with a child that is helping you, you want to put them on as an additional signer, not as a joint tenant. That in itself creates some issues because if you have a child that experiences drug problems, credit problems, or whatever, and they're an additional signer, the bank or credit union isn't necessarily monitoring what you or somebody else is doing to that account, and they could be writing checks to themselves and clean out that account. And if you're not paying attention to the statements, the account can be drained. Nationally, it's believed that the incidence of senior abuse is equal to that of child abuse, and the biggest area is in the financial abuse of older people. So that's a big thing. One other thing about joint tenancy, the bottom part there, is joint tenancy overrides the provisions in the will or trust or prenuptial agreement. However that joint tenancy is, that is where the property is going to go. And occasionally people will have assets and they'll put it in joint tenancy and then with one of the kids, and in the will it says it gets split up equally. And as I said earlier, that the will does not control joint tenancy assets, and a trust only controls the assets that are owned by it. So therefore, if the account is owned by the original owner and a joint tenant, it's not covered by the trust. So joint tenancy is useful. It's particularly, like I say, between surviving spouses, but that's where I would limit it. One thing also, most of people's wealth today is concentrated in two areas. It's in their home and it's in their retirement accounts, either IRAs, annuities, or 401ks. But all of these have one thing in common. IRAs, 403Bs, 401Ks, pensions, annuities, life insurance. They all have what's called a beneficiary designation form. And where the property goes to is determined by contract law, and it's determined by who is on that beneficiary designation form. And if you don't name a beneficiary, usually within the contract, it will spell out who it goes to, and it usually goes down lineal designations. But we've seen some very unusual things happen in with beneficiary designation forms that are unintended bad consequences. I was in the military for 28 years, and when we were going through basic training, they got all of us little guys together and handed us the Servicemen's Group life insurance and said, here's some insurance. Who do you want as your beneficiary? Well, this didn't happen in my unit, but it happened in another unit. One of the people had gone downtown to one of the dancing establishments downtown and fallen in love with a lady down there. And so he named her as his beneficiary on his life insurance policy. He went over to Vietnam, and after letters back and forth with his high school sweetheart, they decided to meet on R&R and get married. And they did, and he went back to Vietnam and sadly was killed. Much to the dismay of his new wife, his life insurance policy was paid to an exotic dancer outside of Fort Benning, Georgia, as opposed to her. And the law says it goes to whoever the beneficiary is. And so there can be situations on there where you name you name your children, for example, and you leave one off by accident, and it goes to the ones that are named. Another thing that comes up occasionally, people will get divorced and they don't change their beneficiary designation form. There isn't a provision in the federal law that overrides that and says, oh, by the way, if you get divorced, that cancels it. No, that's what happens. This also overrides the provisions in your will and your trust and your prenuptial agreement. And again, given the fact that for most people, the majority of their liquid assets are in their retirement accounts or these things, it's really important that you have these beneficiary designation forms filled out correctly. What I suggest that you do is, if you have any of those type of accounts, you contact whoever the custodian is for those, or the insurance company, and ask for a copy of the current beneficiary designation form, and then make sure it's what you want. And if it isn't, then get a new form, complete it, send it to the company, and ask them to send you a stamped copy of it back showing that they received it. Because occasionally people will get the form, fill it out, but never send it in. And or it never gets to the insurance company. And so you just need to make sure that what you want to happen will really happen. Another thing we see as an alternative for accounts is what's called payable on death or transfer on death, POD. If you've got something for a child, let's say you've got 2 or 3 children and you've got a savings account, you want it to go to them, you can name all of them, and at the instant of your death, it becomes owned by them. But the great thing, unlike joint tenancy, you don't create a present ownership in that account. So if one of the kids does something you really don't like or whatever, you can take their name off of it and you don't have to go through a lot of difficulty. I can tell you on joint tenancy, if you put someone as a joint tenant on a stock certificate, a publicly traded stock certificate, 9 times out of 10, they're going to require the signature of both joint tenants if you want to remove that joint tenant. We had a situation where a mother had a child who joined a religious cult, and she didn't want the child, she had put the child on as a joint tenant on a block of stock, and she didn't want the child to get the stock and give it to the cult. So she was going to remove him, and the transfer agent said, no, not without his signature. Well, you can imagine he's not going to sign it. And today, stock certificates require what's called a medallion guarantee. So the person has to go before a bank or a securities firm and prove who they are and sign it in front of them. And so even forging their signature is not that we advise that, but it's an impossibility. The nice thing about POD, immediate liquidity, predeceased beneficiaries and multiple beneficiaries, if you don't remove them, the question is, does it go to their heirs then? Sometimes people like the spouse of their children, sometimes they don't. And so if you've got a child named on there and they die, normally then it's going to go to their heirs. Again, this overrides the provisions in the will or the trust. And so if you want, as we'll talk about trust in a little bit, if you want your trust to govern the document, then, or govern the assets, then you want to make sure that it is owned by the trust and not by one of these payable on death, joint tenancy, or other life estate ownerships. Lastly, the thing we're seeing also today is people putting their assets in partnerships or limited liability companies. And they're putting their assets in there, and then there's an operating agreement that tells how the assets are going to pass. The interesting thing about this is that it can be very useful for dividing up an operating entity. Let's say you've got a cattle feeding operation or a business, an ongoing business. It makes things a lot easier for gifting shares to people within the permissible annual gifting limits. But there's a downside to it. You have to have an attorney draft it. There are tax returns that go along with it. You need to abide by the various laws and regulations, and it's governed by the operating agreement and not necessarily by your will. The one thing, the challenge that some people see in very successful and high value partnerships or LLCs is that the shares themselves get a step up in basis, meaning that if they were worth $100 originally when set up, but now are worth $1,000, normally at death, a person would have to pay the difference between the $100 and the $1,000 and pay capital gains, but you'd get a step up in basis. Unfortunately, in the LLC though, let's say there's farm ground that's in there at $300 an acre and now it's worth $10,000 an acre. Although the LLC assets would get a step up in basis, or the LLC would get a step up in basis in the estate, the underlying farm wouldn't, so that when the LLC would go to sell it, it would end up passing out taxes. And so, but we're seeing more and more use of entities for businesses and farming. Lastly, you've got your individual name and holding assets, and those things are what are going to be governed by your will, or if you don't have a will, by what's called the intestate laws. Each state has on its books a series of laws that says if a person doesn't have a will, this is who the assets go to. Usually it follows the bloodlines. It will start with a spouse, or if they're not married, it will go up the chain through the parents. But anything owned in your individual name, you're going to need some mechanism to get this moved to someone else. And that's where the will is going to be in place. Let's say, for example, you've got 100 shares of Berkshire Hathaway, if you're lucky enough, and you want to leave those to your kids. And so at your death, your kids come and say, here's a note from mom and dad saying that we each get 1/2 of these Berkshire Hathaway shares. The transfer agent will not honor that. They're going to say, I need an order from a court that tells me if I follow this order, I won't get held liable for it. And so banks, savings and loans, virtually anybody, any type of real estate, if it's in your name, it will need to get transferred by what's called probate through the will. And probate can either validate your will, or you can go what's called intestate, which then the court looks at the laws and who your blood relatives are. Again, it's court supervised to make sure the terms are followed, protects the spouse. The one thing that the laws in all the states provide is that, let's say a married couple, one of the spouses disinherits their spouse. Usually the surviving spouse can take an election against the will to claim half of the estate if they get left out. And under federal law for retirement plan assets, normally you have to have spousal consent also to give more than half of your assets to, let's say, your children as opposed to your spouse. I mentioned here intestacy might work for a traditional family, but there are fewer and fewer traditional families out there. And I can just tell you that more and more, with 32% of the people under the age of 40 depending on their parents for some part of their living funds. There's a lot of young people out there that are just waiting for mom and dad to die so that they can get their hands on the assets. Sad, might sound like a cynical view, but that's what the statistics are. And so, and different members of the family may have different situations. And so intestacy, to me, is not a good alternative. Will works better, particularly if you've got a second spouse or a special needs child. I'll talk about special needs trust in a little bit. I mentioned here, works best for the property and the estate of your domicile. Where you live will determine what tax and what laws apply. But if you, and it's not uncommon here in Sioux City, Iowa, to have people that own property in all 3 states, South Dakota, Nebraska, and Iowa. And the court where your will is probated only has jurisdiction of the property in the state. And so if you own property in Nebraska and South Dakota, you may have to have what's called an ancillary probate in each of those states to pass that property if it's not in some form of ownership that doesn't need that. So now we get to the thing that, the topic, the trust. So what is somebody, why would somebody want a trust? Well, a trust is a legal agreement that basically can do anything that is not prohibited by law. And you can be as basic or as complex as you want with trusts, but trusts are usually where you're trying to have a person or an entity like a trust department do something with your assets specific that you want. If everything is in your trust, owned by your trust, it will operate much like a will. Now, the one thing I would say about a will, though, is a trust can only administer property. A will can designate to the court who you want as a guardian for a disabled or minor child or a disabled relative who you're guardian for. Ultimately, the court gets to make that determination, but you can nominate a primary and a successor. In a trust, you can say who you want to manage the money for that person, but you can't say to the court who you want to actually have physical custody or who you want to determine medical care, for example. You might have a 50 or 60-year-old challenged adult who cannot function on their own. And might need to be in an institutional environment. Who is it that can authorize the doctors and the nursing home to care for the person? That's why a will and a trust is always good. As I said, it can be good for out-of-state assets because, again, the trust, because if it's located in this state, that's where it would be administered. Even though the assets are outside the state, the trust is here and it can still do that. It's good for those complex and continuing situations. One thing we see here in the Midwest is for families that want to keep a farm or an operating business entity together, and they want to bring the family together, they can put the farm in the trust and all the children get to benefit and work together on it. And then you work out the details in the trust of how it will be managed going on. Do you need a trust instead of a will? No, I think you need a trust and a will. What is a trust? The formal agreement by which the grantor, that's you, the person with the property, transfers the title of assets to a trustee. That's the person who's going to do all the things that you want to do, to manage for the benefit of designated beneficiaries. Say, for example, you have, you're married and you have a spouse and you have children. You might say, I want to leave my assets in trust so that my spouse can have all of the income during his or her lifetime and such amount of principal as they need and request from the trustee. And then at their death, I want it to go to my 3 children. You can make it a little more complex if you wanted to. You could say, I want the assets to go to my spouse, but because my spouse already has a lot of assets on their own, I don't want to increase the size of their estate. So what I'm going to do is I'm going to leave my spouse with an income right and the ability to designate where the property is going to go to at their death, but it won't actually become owned by them. And thereby it bypasses their estate and avoids federal estate tax and inheritance tax. So you can, again, you can be very creative with this. There are 2 basic types of trust. There's what's called the inter vivos trust, and that's the revocable trust, and the testamentary trust. Inter vivos trust can be revocable or irrevocable, but most of the time, the ones that are used for probate avoidance are going to be revocable living trusts, meaning I create them during my lifetime. I can go in and change them anytime I want during my lifetime and as many times as I want. Testamentary trust would be a trust provision that would be included in the will. And so if you change your will, you would need to change, it would change that trust provision possibly too. Now, there are people that create what are called inter vivos or living irrevocable trusts. And most common, those are used to put assets outside your estate during your lifetime. And like it says, these are irrevocable, so you can't, for the most part, go back and change these. You might say, well, why would anybody want to do that? There are 2 primary reasons. Mainly tax minimization, because let's say, for example, I've got an asset that is appreciating dramatically. I might gift it to an irrevocable trust right now, and because it's in that trust, any of the appreciation is not, that between now and my date of death, is not going to be taxed in my estate. So if you put a piece of farm ground at $1,000 an acre and it goes to $10,000 an acre in that irrevocable trust, you're not going to, and the person dies, the grantor dies, they're not going to have that tax issue in that estate. Another reason why you might want to do that is to also protect assets from creditors. So if, for example, in Iowa, what are called asset protection trusts, if I'm in a highly hazardous profession, let's say I'm a doctor where I have a high probability of getting sued for malpractice, I may take half of my assets and put them in an irrevocable asset protection trust in South Dakota. And if somebody sues me and I've met the certain time requirements and the lack of judgments pending against me, those assets can't be reached by my creditors. And so for people that are in higher risk professions, that might be an advantage to them. The traditional uses of trusts, like I mentioned here, professional management of the assets. My wife, for example, she was a nursing professor before she retired. She didn't work with money normally. And so if something happened to me, I would want somebody to help her in the management of my retirement account, which I have designated to pay into my trust, and the other assets that we have. Now, she would ultimately be able to override that and replace the trustee if she didn't like the trustee, but she would then get the benefit of the professional management of the assets. And it's sad because when we see people that pass huge amounts of money or complex business entities, an active farm, to a person that has absolutely no knowledge of how to manage that, they can be victim of all kinds of scams and schemers, or just the lack of productivity. Right now, for example, where most savings accounts or checking accounts are paying virtually nothing in interest. If a person inherited a bunch of certificates of deposit and cashed them out and put it all in the checking account and just let it sit there, it wouldn't get them a dime of interest. And if they were going to have to live off those assets, they would start spending down principal rather than spending income off of it. So having a trustee that is a professional in management of the assets would help them with the investment and when it would be appropriate possibly to sell some of the assets. I mentioned tax minimization, keeping assets from getting combined together in estates. Back when the estate tax exemption was smaller, and you could only have $1 million of assets, it was not uncommon to try and keep the two estates smaller, the husband and wife's estates smaller, by each of them having their own assets in their own trusts, so as to avoid piling up assets in one estate, in the estate of the survivor. One of the things with federal estate tax is that there is what's called the unlimited marital deduction, and sometimes people are fooled in that if I die and leave everything to my spouse, great, there's no federal estate tax due. Well, but the trouble is, then if I had 11 million and my wife had 20 million, of course, if I had that much money, I wouldn't be sitting here right now. But anyhow, if we had that, if I died, all of a sudden, my wife now has an estate of $31 million, well into the area where the government's going to take over 40% of it. And so by keeping it separate, you're holding down taxes. I mentioned earlier, if you've got a second spouse, it's not uncommon for the person to want to provide for that second spouse, whether it's a husband or wife. Excuse me for a second. But they also want to make sure that the children are provided for. And so what they will do is say to the trustee, I'm putting these assets in trust, give my spouse all the income off of the trust and whatever principal you think, you trustee, you think is necessary. Now the spouse can't demand it, but the trustee can pay, and let's say they need a special medical treatment, or there can be a variety of things. But let's say the second spouse decides to remarry and they're with their third spouse now. They can't just go in and gut the trust and say, I want all the assets. So like I said, what you do is you say, I want to provide income for the second spouse, and then it passes to my kids later on. Now, I'll tell you though, that creates some challenges, because the second spouse is used to living with their spouse and having pretty much unlimited income. At the death of their spouse, the assets that are there, all they have is what those assets are producing, which usually is much less than what they were spending before. And so this second spouse is always saying, I need as much income as I can get. I want the trust to be out there investing for income. The children are saying, on the other hand, wait a second, if you invest in income-only assets, those assets aren't going to appreciate at all. And because of inflation, they're actually going to go down. Their relative value is going to go down. So we want you to invest those assets in something that's going to appreciate, like a stock, something that's going to be worth more later on. So you end up with this battle between the surviving spouse and the children's spouse saying, I want all the income, I want you to go 100% income. Children saying, no, I want you to go 100% growth. Usually the trustee is going to be in a 60-40 range there, or 70-30, where they're going to have 70% of the assets producing income, 30% growth, or 60-40, might even be 50-50, to get a balance that respects both parties. Now, suppose you have some issue, a spending problem, you've got a spendthrift. This, a trust can be very useful. You can say, my son or daughter, they've just had problems all their life. They can't manage their money. So I'm going to give this money to the trustee, and the trustee can provide for their health, education, maintenance, and support. It's affectionately called HEMS. And the child themselves cannot demand any money, but the trustee will look out for them and pay for what they need. The nice thing about these trusts is that no matter what the child does, if they get in a car accident, it's their fault, they go out and run up credit card debt or whatever, the creditors can't get to the assets in the trust. So the trust is able to continue to pay rent, maybe pay medical insurance for them, pay utilities. So even when they're still experiencing their problems, it can provide a certain minimum standard of living for them. Again, if you've got a spouse issue, you can provide for the spouse and make sure that they're cared for. Let's say even as people get older, maybe they're not mentally capable of managing the assets. This way, the assets will be provided for, but somebody cannot come along and victimize them. Unfortunately, some of the children that are providing care, it's not uncommon for them to come along and ask for a distribution of assets, discretionary, and having the spouse not able to do that on their own, that makes the child have to go to the trustee and justify it, and it provides a level of protection. The thing where you're going to hear on television and radio is, why should you have a trust? Well, assets are going to get distributed faster through a trust than under a will. It's going to be cheaper because you're going to avoid probate costs, and it's going to be private because the trusts are not filed with the court, so the terms remain private, which, if all things work like they're supposed to, these things are probably true. Unfortunately, we all know that life just doesn't work the way we always want it to work. And so even in a trust, when you're settling a trust, you're going to have to wait for the final bills to come in for the hospital, medical insurance claims, possible sale of assets, and you're going to have to clear the final federal or final income tax. And so while the trust can continue to pay benefits and can start to pay benefits to the other beneficiaries immediately, they can't distribute everything. And so there will be a time. Probate generally takes at least 6 months to accomplish. And in my experience, anything but a simple trust that had just cash and securities in it probably is going to take somewhere between 3 and 6 months to wrap up, just because of those first things that I mentioned. Now, I just mentioned to you that both the trustee and the executor can make distributions of property while administration is going on. You know, people say, oh, well, you're going to have to wait for the estate, the will, to get probated to finish up to distribute. No, it's not uncommon here at the bank when we're probating an estate to do distributions along the way as cash builds up and we know that there's assets in excess of expenses. So that's not necessarily true about trusts being faster. What are the costs? Is there savings with probating or not probating an estate versus doing a transfer? Very seldom are you going to see a trust wrap up without the benefit of legal fees, without an attorney being involved in helping whoever the trustee is wrap it up. The cases that I've seen where people have tried to do it on their own and have not consulted an attorney, usually there's a train wreck at the end of the tunnel. And so there's going to be some expenses. What are probate expenses? Usually the probate costs, the court costs, are about 0.5%. The total costs for probate are going to range between 1 and 2% of the value of the estate. And that usually will be the attorney's fees that are involved. If you have a trust, usually the trustee fees are going to be somewhere between that 1 and 2% range. Now, you can have a family member that is serving as a trustee that says, I'm not going to charge a fee, like a surviving spouse. That might be one of those exceptions, but generally we see family members even charging to be trustee because of the liability and because of the time it takes. The other thing is, if you're going to use a trust, you're going to have an attorney draft the trust. Now, I know that somebody out there saying, hey, I hear the legal Zoom ads on TV and radio all the time. Could you go out there and find a trust document on one of those sources and do it yourself? Yes, you probably can. Should you do it yourself? I don't practice medicine or dentistry on myself because at least on the few times I've tried to do minor procedures, it hasn't turned out well. But you can try practicing law on your own, but I guarantee you it will, if you do something and you make a mistake, you will spend several times more money trying to fix what got broke than what you would have spent if you just would have sought advice from a trusted counsel and done it right in the first place. I notice here, while a will is filed in the court, a trustee is going to have to file some of the same information for inheritance taxes also. So it's not going to be totally as private as you think. Maybe all of the provisions of the trust might not be out there, but the trustee is going to have to file tax information. Now, you may say, well, why would privacy be a big deal? Well, sometimes people have interesting provisions in their trust. Like I said, a trust can do anything that's not prohibited by law. When I was in Nebraska, a trust that I saw, there was a lady who wanted her son to go to church, and he didn't want to go to church. So she specified in her will that he had to go to church, get a bulletin, and have it signed by the pastor for 52 consecutive weeks. And if he did that, then he would get $50,000. The court upheld that provision. said, that's not that unreasonable. Now, this woman, though, she wanted to control things more than that, and she hated her son-in-law. And so she also put a provision in there saying that if her daughter would divorce her husband, she would give her, I think it was $100,000. As a matter of law, the courts will not support things that destroy marriages by their provisions, and so they did not uphold that provision. But that was an interesting provision. One thing you might see out there is you can incent children or grandchildren to do particular things. Like, for example, you can say, I'm going to pay for the education of my grandchildren, and I will pay for, you could specify a school. They have to go to my alma mater, which we've seen, or I will pay all of their tuition to a particular religious school or particular state school for the first 2 years. And then if they have at least a B average, I will pay 100% of their tuition, room, and board for the next 2 years. But if they have a C average, I'll only pay 75%. And if they've got D's, I'll only pay 25%. So you could put out there saying if they graduate from college, I'll pay the tuition and they get a brand new car when they graduate from college or professional school or whatever. So you can be creative. Let's see. At the bottom, one thing that's nice about a living trust is in the United States, most people are going to spend the last 5 years of their life in a state of diminishing capacity. And it's not going to be like one day you are absolutely coherent and logical, and the next day you're absolutely out in Never Never Land. Now, there can be a person that has a stroke that instantly becomes incapacitated, but most of us, we are going to gradually lose our capacity. A trust can provide that with the assets, and they're saying that if based upon a statement from my doctor and my attorney, or my doctor and my minister, or doctor and somebody else, a good friend, that I am incapable of managing my affairs, my trustee will then take over responsibilities. And so you don't have to go into court and get a conservatorship order or anything. You can have a mechanism in place that would automatically take over that, in conjunction with the power of attorney, would be able to take over in the event that a person became incapacitated. And that's the thing we're seeing more and more, is people in a diminished state of capacity, which then causes them to be more susceptible to victimization. I mentioned irrevocable trust can offer creditor protection and management. South Dakota has probably got one of the strongest asset protection trust statutes, but we have quite a few trusts, what are called spendthrift trusts, where the beneficiary, the son or daughter, went out and ran up huge amounts of credit card debt, and they've tried to get to the assets and they can't get to them. And so that is particularly beneficial. Another thing that is, it's not mentioned here, but are what are called special needs trusts. Let's say you have a child that, or someone who is receiving government benefits that are need-based, and the person doesn't have a lot of assets, and you want to leave them something, but you don't want to do it in such a way that would disqualify them for their government benefits. You can create what's called a special needs trust, which specifically says, I'm leaving little Johnny in trust $100,000, but the trustee is limited in what they can do with that money. They can't pay for anything that the government would pay for under government benefits, or do anything that would disqualify Johnny for his government benefits. But he can do anything else. And you might say, well, then what can the trustee do? Well, let's say Johnny's in a nursing home. Johnny can go on field trips. You can buy clothes for Johnny. If Johnny needs a new TV set, we have people who have particular hobbies, and we can buy things for their hobbies, things that enhance their quality of life that aren't covered under the government benefits, but this special needs trust would take care of, and the government can't get to those. So there's an advantage there. Life insurance trusts, or charitable trusts. Suppose you have your church or some charity that you want to benefit, and you're really concerned that, you know, if I give the money to them, I know that they're going to go out there and they're going to build a giant palace, or they're going to pave the parking lot. And I think that's a stupid idea. You know, what I want them to do is just use the money, in quotes, wisely. Well, you can set up a charitable trust in your estate, in your trust, that says, I'm going to leave the property to ABC Church, for example, and they can only use the income on that property. And so they get what's nice is they get a regular check on an annual basis from the trust. And every year your name gets remembered. John Jones just gave us a check. His trust just gave us a check for $5,000 to help on youth ministry or flowers or music ministry. You can provide scholarships. I'm going to mention two trusts. These are public trusts, and so that file public tax returns, so I'm not breaching any confidence. But Cornelius Duggan set up a trust back in the 60s with $500,000 to pay scholarships to students graduating from the local high schools. Since that time, that trust that we work with has paid out over $6 million in scholarships to local students, and the trust today is worth $3.5 million. And it started with $500,000. Some of you may see the name Gilchrist around in the community. Jocelyn Gilchrist, her family was from this community. Jocelyn set up in her estate that she had no children, she was never married, left all of her assets to a charitable trust, roughly $20 million. And it was directed that it could only support things that deal with music, art, wildlife, nature preservation, and catastrophic natural disasters. That trust started with 21 million. It's paid out, I believe, 16 million, and it's worth 37 million today. Yeah, those are bigger numbers, but like Cornelius Duggan's, it's $500,000. Even with $250,000, you can provide very nice scholarships for kids. Or you can, like I said, with Jocelyn Gilchrist, the nice thing is that trust specified arts and culture and wildlife. And you might say, well, that's great. Well, it is in that most of the foundations in this community support things like feeding children, healthcare, education, homelessness, that kind of thing. And to have something that's specifically carved out for that segment of the not-for-profit community, at least they know that there's some money out there always, that they're not having to go head-to-head with a shelter or the food bank or the Council on Sexual Assault and Domestic Violence. So charitable trust, you can accomplish a lot. And if you wanted to perpetuate a legacy, you can do that. If you're thinking about working through a college or a hospital or those kind of entities, the community foundation, they can help you set that up. Life insurance trusts, one of the things for people, they may have a big life insurance policy and they don't want the death benefits to become part of their estate. You can set up a trust and put the life insurance policy in the trust. It'll keep it out of your estate. Something that you don't see a lot of is the last thing there, these family or dynasty trusts. I think we've all heard about, you know, the big families on the East Coast, the Vanderbilts and the, you know, all those folks. What they do is they've put their money into what are called dynasty trusts. And normally under Iowa trust law, for example, and Nebraska trust law, a trust has to end within 21 years of a life in being. That means one of the beneficiaries, the youngest one, it has to end 21 years from this date. South Dakota and about 14 other states allow trusts to go on perpetually. And so I could set aside assets in a trust that says, my kids will get this, all the income off of it during their lifetime, but they get no principal. Their kids get all the income off of it during their lifetime for their education, but no principal. Then, you know, and just keep on going and going and going. And that's how families have amassed these millions and millions of dollars, is these perpetual trusts. Now, if you're a beneficiary of those, it's a two-edged sword. You might say, gee, I like this getting my tuition paid for, but knowing that there's millions of dollars out there, you might say, well, why can't I have the millions of dollars? And so, not always happy about that. I hope I've given you some basic ideas there of trusts and how you can use trusts. And now that I've babbled on and wandered all over the universe, do you have any questions?
So if people want to unmute, this is a great time. And Joe, I'm going to stop your screen sharing so we can go back to everybody's faces. So if you want, I'm going to go ahead and stop the recording and we'll do questions off of this. Okay.